DUI charges with no evidence of driving. I get calls all the time. Marc Lopez, they've charged me with drunk driving, but there is no evidence that I was behind the wheel. And so I'm always get excited when I hear that because, oh man, let's fight this. And start talking to the client. 99% of the time, what the client really means is there's weak evidence of driving. So there was a crashed car and the client was found, half mile up the road. There was a crashed car, but the client was found at his home. They had the airbag and the car went off and the client had a scratched up face. And his wife's like, he was driving, but the client doesn't say that he was driving. Or there is some just weak circumstantial evidence of driving. Now, the crime of DUI is actually the crime of OVWI, operating a vehicle while intoxicated. So the person has to be convicted beyond a reasonable doubt of operating the vehicle. But beyond a reasonable doubt, it's kind of in flux with DUI. They're always making exceptions for DUI. Basically, can the fact finder, the judge or the jury, connect the person with that car? So what we see is, depending on the judge, depending on the county, depending if it's a jury trial, depending if it's a bench trial, but weak evidence of driving, they can file those charges against the person. And that's where the attorney comes in now. And we can fight those charges. And quite frankly, I love going to trial on cases like that because I don't want anyone to plead guilty or be found guilty on weak evidence. Make the state prove their case. So yes, they can charge you with weak evidence. They can charge anyone with anything, but they can't convict with at least some evidence of driving, which is technically operating in Indiana. If you have any questions about DUI law, give me a call. My number is 317-632-3642. But most importantly, remember to always plead the fifth.